Right friends, welcome back to editorial discussion. The first one, let us go ahead. Insolvency and Bankruptcy Code is the legal framework for the development of credit markets discuss. This is the statement uttered by the Supreme Court. So this is from the Supreme Court judgment when Supreme Court uphold Insolvency and Bankruptcy Code. Right, Supreme Court also said that it is a clear message. That means Insolvency and Bankruptcy Code is a clear message that India is no longer the defaulter's paradise. And before going ahead, what is this Insolvency and Bankruptcy Code? Let us see here. State Bank of India and ICICI Bank, they gave around 1000 crores of rupees to some company, say Bhushan Steel. Let us take for example. And ICICI Bank and SBI as consortium of lenders, they gave money to one of these companies, and later on they built this steel factory or steel company, right? Money is given by SBI and ICICI Bank. Please don't forget, as they have given the money, they are called creditors, very important. So these are creditors and these are debtors. SR Steel or Bhushan Steel or Kingfisher Airlines, whatever the case may be. So these banks are creditors, these are debtors, and they gave loan. They constructed one factory, let us say steel factory, but there is a problem. This steel factory is not able to perform well. There are some changed circumstances. Global steel prices crashed. I am taking for example. Right, for example, let us assume the global steel prices crashed, the demand for steel reduced, and there are alternative materials available. So let us assume these examples, or you can say let us assume these circumstances. Under those circumstances, though the intention of the debtor, or you can say though the intention of the company is good, but because of the changed circumstances, then they may not be able to pay back the loans, right? So here, these are the creditors, they gave loan, and these are the debtors, they have taken the loan. Later on, they built one factory, they are supposed to pay back, but they are not able to pay back. And business loss is quite common. When there is business loss, what is to be done? And to solve this, this is known as resolution. So resolution is nothing but when there is some problems with regard to businesses, then how to bring them out of the problems. That is resolution. So Insolvency and Bankruptcy Code, the main purpose is how to resolve when there is difficulty, when there is problem, how to come out of the problem, how to solve the problem. That is resolution. So resolution, that means this company is again to be put on track. That means this company should be put on track, and for that some new management may come. Some new persons may come, some new persons may purchase it. That is resolution. So resolution is the ultimate goal of Insolvency and Bankruptcy Code. And if resolution is not possible, then what happens? It will go for liquidation, very important. That means when resolution is not possible, it will go for liquidation. That means we have to sell it. And various terminology, please don't forget, committee of creditors. Committee of creditors means they have given the loans, so they are creditors. Committee of creditors, they decide with regard to the resolution plan, and to decide about it, there will be one resolution professional. Resolution professional will have full powers, right? So till the resolution plan is approved, the managerial powers rests with resolution professional, and resolution professional is also appointed by the committee of creditors. Right friends, so committee of creditors, they decide about resolution professional, they decide about resolution plan, and if resolution is not possible, the ultimate goal is liquidation, right? And you may ask a critical question, 2 years for Insolvency and Bankruptcy Code, and what is being happened in 2 years? There are 3-4 problems. One is, it is facing teething troubles. Several people, or you can say several companies, several aggrieved companies, they are going to the courts. So that is one important aspect. So second important aspect with regard to insolvency and bankruptcy code is timeline is not being adhered to. Timeline is 180 days, which can be extended to 270 days overall. But there are number of cases which crossed 270 days, and some of the cases are because of the court's intervention. And third important aspect is the main purpose of insolvency and bankruptcy code is resolution. That means how to put the company on track, how to maximize the value, how to maximize. When the value is maximized, then everyone will be benefited. Maximization of the value of the stressed assets, that is the main goal of insolvency and bankruptcy code. But unfortunately, several cases are going for liquidation, and liquidation should be the last resort. Right. So if you look at the insolvency and bankruptcy code for the past 2 years, because 2 years already completed, if you look at for the past 2 years, one is timelines are extended. Second is more and more cases are going to the court. Third one is instead of resolution, more cases are going for liquidation. Liquidation should be the last resort. Then these are the important points one should not miss. Or you can say insolvency and bankruptcy code is still evolving. It is coming out of initial teething troubles. Under these circumstances, Supreme Court now in fact upheld insolvency and bankruptcy code. Certain points it told that it is no longer, or you can say India is no longer the defaulter's paradise. Prior to insolvency and bankruptcy code, this defaulters, or you can say the debtors, used to drag. But now the issue is shifted towards the creditors. That means the power shift is there. The power shift is towards the creditors now after insolvency and bankruptcy code. Now the promoters are highly cautious and careful, because once the case goes to insolvency and bankruptcy code, the management will go to the insolvency professional. So therefore, now the tilt is towards creditors after insolvency and bankruptcy code. Rightly, the Supreme Court pointed out, now India is no longer the defaulter's paradise. Right. So it is the code for reorganization and insolvency resolution of corporate debtors. It maximizes value of the assets of corporate debtors. Right. It promotes entrepreneurship. It enhances the viability of credit in the hands of banks and financial institutions. Right, friends, certain words I am not explaining fully. Please watch 360-degree view. We deliberated insolvency and bankruptcy code. Certain important words are there. Committee of creditors. Second is insolvency professional, resolution, liquidation. Then the next important word is financial creditors, operational creditors. These words are very important when one looks at insolvency and bankruptcy code. Right. So let us move ahead. What Supreme Court said, 3 things are there. First one is the court partially struck down section 29A. That means if the company, suppose you see, if this company defaulted, let us take for example, if the company defaulted and in the resolution plan, that means some other person will come and bid for this company, right? Bid for this company by some other firm, that is known as resolution plan. And in the resolution plan bidding, as per this section 29A, the relatives and related parties are banned. But now Supreme Court said, why are you banning the relatives? Only when they are connected with the business, when they are connected with this particular business, so ban them. Otherwise, relatives can bid for this during the resolution plan. That means this company defaulted and later on in the resolution plan, some other person will bid for it. And Supreme Court said, why are you barring the relatives? Relatives may not be associated with this company. Then under those circumstances, don't ban them, don't bar them. So that is the point struck down by the Supreme Court. If at all relatives, related parties are related to this company, related to this business activity, then bar them. Then second point is it upheld relaxation for MSMEs. That means government brought the change that promoters of MSMEs can bid for the enterprise during the insolvency resolution process. That means while the resolution plan is being put up, the promoters of MSMEs, they can bid. This exception was given by the government because MSMEs are suffering a lot. So now Supreme Court upheld this. Then of course Supreme Court in fact not approved the contention of the operational creditors. Operational creditors asked some powers with financial creditors. And what is operational creditor? Have a glance at it. Here, to build a company, these banks gave loans, and while building the steel factory, here this is steel company, this is cement company, this is chips company, they gave, or you can say they supplied goods. Very important, this Bhushan Steel is constructing steel factory at that time. This is cement company, this is chips company, metal company, this is steel company. They supplied steel, cement, chips, aggregates, all those things. And while the construction is going on, when these firms supplied certain materials or certain services, these are known as operational creditors. Right? So operational creditors are the creditors who supplied some goods and services during the execution of the work. These are known as operational creditors, and these are financial creditors. And financial creditors will get some precedence, or you can say some more powers are there for the financial creditors in comparison to operational creditors. Now Supreme Court in fact upheld that distinction. Supreme Court said if they are giving loans to these companies, they are of course all of you are familiar, these are known as financial creditors. These are operational creditors, very important. These are operational creditors, these are financial creditors, and there are powers. That means financial creditors will get upper hand in some aspects as far as the Insolvency and Bankruptcy Code mechanism is concerned. And now Supreme Court upheld certain privileges to the financial creditors in comparison to operational creditors. Right? Why? Supreme Court said financial creditors, they are important in the architecture of economy, because if these companies pay back to these banks, or you can say financial creditors, then they immediately give loan to some other company. So they are important in the financial architecture. That's why the Supreme Court upheld certain advantages and powers given to financial creditors over the operational creditors. I hope you got the point. In the payment waterfall, in case of liquidation, that means if the company is sold, there the preference is there for the financial creditors, then workmen, employees over the operational creditors. And now that is upheld by the Supreme Court. So therefore, it upheld the supremacy of financial creditors in comparison to operational creditors. This is the important aspect to note. Right, friends, we had enough thought-provoking discussion on Insolvency and Bankruptcy Code. And here, what the Supreme Court said now with regard to operational creditors and financial creditors, Supreme Court said there is intelligible differential between operational and financial creditors. Here, repayment of financial debt by borrowers. In fact, later on, these banks will lend to some other company. So therefore, it propels the economy. So therefore, financial creditors, they should be high in the waterfall in case of liquidation. Right, friends? So it gave certain legitimacy for having the upper hand of the financial creditors in comparison to operational creditors. Right? This is with regard to the Supreme Court upholding Insolvency and Bankruptcy Code. Right, friends? This concludes today's editorial discussion. Have a nice day. Thank you.